Have you ever been sexually harassed at work? Hi, I'm Simon Dippenaar and I'm an attorney. In South Africa, sexual harassment is distressingly common. Approximately 30% of women had experienced sexual harassment in the workplace, according to a 2019 survey by the South African Human Rights Commission. Harassment not only takes a huge psychological toll on victims, there are also serious financial consequences, especially for women. Many women have been pushed out of well-paid, male-dominated industries and forced to take up employment in lower-paid fields or accept jobs with less certainty. Many have experienced some level of loss of work or involuntary job change. Now, although sexual harassment can happen to both men and women, it is behavior predominantly perpetrated against women by men. Sexual harassment is unwelcome conduct of a sexual nature that violates the rights of an employee and constitutes a barrier to equality in the workplace. The conduct must be unwelcome for it to amount to sexual harassment, and you can indicate this either verbally or non-verbally, even if you previously welcomed the conduct. For example, if it is from someone you used to be in a relationship with, if the conduct has become unwelcome, you're entitled to lodge a complaint of sexual harassment. What recourse is available if you are being sexually harassed? What responsibilities do employers have to protect you? The Employment Equity Act (EEA) prohibits unfair discrimination against an employee on multiple grounds, including race, gender, sex, marital status, and more. All forms of harassment are considered a form of unfair discrimination and therefore constitute a barrier to equity and equality in the workplace. Harassment may be sexual, but it can also include bullying or racial, ethnic, or social origin harassment. Harassment may be physical, psychological, emotional, or sexual. The Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace is part of the EEA and applies to all employers and employees. The Code aims to eliminate all forms of harassment in the workplace. Employers need to make sure that company policies and procedures are in line with the Code, but employers have a duty to prevent unfair discrimination and harassment and not simply ensure reporting procedures are in place. The Code requires harassment to be reported, and I quote, as soon as reasonably possible in the circumstances and without undue delay, unquote. However, it acknowledges that victims of harassment may find it difficult to speak out, especially if the perpetrator is senior to them. So it goes on to say, and I quote, taking into account the nature of the harassment, including that it is a sensitive issue, that the complainant may fear reprisals and the relative positions of the complainant and the alleged perpetrator in the workplace, unquote. If the harassment is perpetrated by a non-employee, the employer has an obligation to investigate the complaint and take steps to protect the employees. This might happen when, for example, a regular delivery driver harasses a receptionist. Harassment can be reported by a third party who is not the victim. In fact, other employees have a duty to do so. As soon as you bring a complaint of harassment to the employer's attention, they should investigate the complaint, consult all relevant parties, inform you of the procedures available to you, explain what the procedures entail and that you may choose which procedure to follow, assure you that you will not face adverse consequences, offer you advice, assistance, and counseling, inform you your complaint will be dealt with confidentially, take the necessary steps to deal with the complaint, and take steps to eliminate the harassment. The Code also encourages employers to consider, in cases of serious harassment, providing employees with additional paid sick leave where they have exhausted their sick leave provision and referring them for trauma counseling. So don't hesitate to ask your employer for time off if the harassment has had an impact on your mental or physical health. You're entitled to it. If your employer fails to take the necessary steps to eliminate the harassment following an act perpetrated in their workplace, they are deemed to have contravened the EEA. The employer may be liable to pay damages or compensation to you. However, an employer will not be liable if they took all reasonable practical steps to eliminate harassment in the workplace. If you're not satisfied with the steps taken by the employer, you can refer a harassment dispute to conciliation or arbitration by the CCMA or Labour Court. Code requires employers and employees to ensure grievances about harassment are investigated and handled in a manner that protects the identities of the people involved. This also applies to disciplinary proceedings. So you don't have to worry about your complaint will become the subject of a workplace gossip. It's worth noting that it is a disciplinary offence to bring false complaints of harassment against any person, and this misconduct may warrant dismissal. It is not unknown for jilted lovers to use a claim of harassment as revenge, but it's not vindication. It's a serious offence. Now, your perpetrator may apologize to you in the hopes that the complaint will go away, However, an apology for the harassment does not preclude the employer taking disciplinary action. The employer is obliged to eliminate harassment in the workplace and where it does occur to prevent its reoccurrence. There are various sanctions an employer may use, proportionate to the seriousness of the offence. Warnings may be issued for minor instances of harassment, but dismissal may also be warranted. If you've experienced sexual harassment at work and your employer has not discharged their obligations under the code, you don't have to accept this. I can help. Contact me on the number below.